Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Kirti Kalra from our Santa Clara office. Hi there, Kirti, and welcome.
Hi, Arianna. How you doing?
Doing so well. Thank you so much for being here with us. For today's topic, we will be answering all your pressing questions on the L visa process. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have any questions, please email us anytime at info@chug.com so we can help you out. So Kirti, can you tell us what are the key differences between the L1A and L1B visas?
Well, while they are in the same category, the two different visas are meant for two different types of employees, two different types of roles in the company. The L1A is designed for executives and managers, while the L1B is designed for employees with specialized knowledge. L1A employees must hold significant decision-making positions within the company, while the L1B employees have proprietary knowledge about the company's products, services, research, or practices that are not easily transferable to anybody without actually having the experience with the company.
Really good to know. Got it. So L1A executives and managers, L1Bs employees with specialized knowledge. Can you explain the typical eligibility requirements for an L1A visa, both for the employee and the employer?
Yeah. So aside from the distinctions I mentioned, if the employees qualify within the categories of L1A and L1B based on their background, their education, their skills, and their roles, aside from those things, the underlying base requirements are the employee must have been working for a company outside the US for one continuous year within the last 3 years in the role that they're going to occupy when they enter the US, such as an executive or a manager, or specialized knowledge for in case of an L1B. And as for the employer must have offices for the duration of the time period that the employee is going to work in the US and must have been in continuous operation during that time, or will be in continuous operation once in case of a new office L1A when the employee enters the US.
Wow, some really important things to keep in mind there in terms of eligibility. So I want to get into the L1B visa a little bit. How do you define specialized knowledge for the H1B visa, and what evidence is usually needed in order to prove this?
Right. Sorry, before I jump onto the specialized knowledge for the L1B, just want to add one more thing about the
Please.
employer relationships. So while the companies have to have multinational offices, they must have a qualifying relationship with the US entity, such as a parent, subsidiary, affiliate, or a branch. And then the offices must be in operations. I just wanted to clarify that. Felt like I glossed over that earlier. But now back to your question about specialized knowledge on an L1B visa. It's specialized knowledge refers to uncommon or advanced knowledge within the company about their proprietary information, such as their products, their services, processes, or management techniques, which are quite different and uncommon in the industry. You may ask, well, how do you even prove that? How do you even explain that? So you would provide detailed job description describing company records that show that the employee was involved in critical projects, internal trainings and documents that evidence that the person went through a rigorous training or process, which is not necessarily available, off the shelf type of training that you can get from any sort of training regimen out there. And examples of that knowledge, what sets this employee apart? You'd have to dig dig into the files to be able to document that kind of knowledge to assure that this person would fall under that category.
Really good to know. Thanks for sharing that with us. So, what qualifies someone as an executive or a manager under the L1A category?
Well, an executive generally directs the management of the organization or major components or functions of the organization, have authority to, establish policies, goals, and make decisions with limited oversight. Basically, somebody that's in charge of a department or a function of the company. As for the managers, they oversee work of other employees, professional employees, or manage a department or a function or subdivision when they're not necessarily all professionals, but there are multi-levels of employees that are reporting onto each other. The supporting documents must clearly define. When we file this, we have to demonstrate it with clear documentation that says, hey, this person has the clear scope to oversee the department and have the decision-making responsibilities.
Got it. Great information there. So, what types of companies can sponsor L1 visas, and what's the significance of the qualifying relationship between parent, subsidiary, and affiliate companies?
Right. So multinational companies with US and foreign offices can sponsor L1A visas, L1A, L1B visas. The qualifying relationship between the US entity and the foreign company must be of such as a parent and a subsidiary or a branch or an affiliated relationship. The relationship is crucial because the foreign and the US entities must be legally connected with such as ownership or control. And the documentation to establish all of this would be such as articles of incorporation, shareholder agreement, so we can show the link, or financial record showing the ownership structures. As the US tax returns, you have to demonstrate large shareholders in there. And then you just have to establish that they're sufficiently connected, whether it's through org charts defining different levels of organizations and shareholder agreements, as I mentioned before, but which list out the subsidiaries or the annual reports, which show the entire picture of the whole company as a larger multinational company.
I want to dive a little bit deeper into the documentation. So, what are the most important documents that must be submitted with an L visa application? Do we have information on that?
Yeah. So for the employee, to demonstrate the employment records for the employee that's going to qualify for the visa, you have to show, employment contracts, payroll records, proof of the employee job role. For example, if it's an executive or a manager per se, the executive or the manager must have signed off on a big deal the company has gotten into, or performance review of employees that they have signed off in the past. That normally would be good from an employee standpoint, along with the org charts demonstrating where they are in the company. As for the qualifying relationship between the US employer and the foreign entity, you would demonstrate it with, corporate records such as minutes, meetings, decisions the companies have taken over the year, organization charts, financial statements, shareholder agreements, any publication the companies may have done. As for I guess I just wanted to add one little additional bit of information for new offices that are opening up in the US from these multinational companies. You'd have to demonstrate with a business plan what the US operation would look like, and what the financial goals and the HR goals for the company would be, and maybe even a lease to show. Actually, a new office will require a lease to show where the employees will be working out of. So if the documents vary slightly depending on the category and the situation the company's facing right now in terms of whether they're establishing a new company in the US from their existing business, or they already have existing companies and they just want to transfer employees back and forth to carry out functions that are important.
Great, I'm glad you mentioned that. We do have a lot of startups as clients, so I think it's important to kind of cover all of those grounds. And as we all know, we do have some larger clients, so I do want to ask a question on their behalf. How should companies approach documenting the qualifying relationship between the US entity and the foreign company?
Right. Like I mentioned, it's the corporate documentation such as articles of incorporation, bylaws, annual reports, org charts, financial reports. Board minutes are very important. They kind of show the direction the company's going, especially if they're opening up a new office, who has authorization to do what their goals are, which kind of would lead into the business plan that the company can eventually create. As per for startups, just another input on the startups that are opening up in an office in the US. Detailed business plans. Take time on the detailed business plan. Not only will it help with the visa, but it'll help with organizing the company when they're actually in the US. So they're not making mistakes. They're not following the steps. There's so much to do when you're opening a new office in the US. There's so many requirements to follow. When you're trying to avoid all of the regulatory and legal requirements, you can get lost in what the goal was of the office and whatnot. So that's why the business plan is so important.
Absolutely, and I think a detailed business plan goes even further than just for visa and legal requirements. They're so beneficial in so many aspects, and staying organized and making sure your foundation is your company's building on a good foundation and following those important steps. So
Right.
what are some effective strategies for ensuring that an L visa petition is successful on the first submission? Any tips?
Yeah, so I guess the employees need to play a large part in these applications than they normally would, such as in a different employment-based visa, such as an H-1B, where the HR department pretty much has a good idea as to what the function is of this individual or what their job duties are that they're going to be performing in the US. But as opposed to an L visa, they have to be sort of in sync with what the person has been doing and what they will be doing in the US. So it's good to sit with the employee to completely understand the jobs, roles, and responsibilities to ensure that the definitions of executives and managers and even specialized knowledge, you know, kind of line up in a sense that you're applying for the right category. And once you go through the job duty, you may realize that this person doesn't qualify for this visa. You maybe try a different type of visa, an H-1B or something along that line. So it's good to get a clear understanding of the job duties that the person has and the responsibilities that they hold in their current role and what their role will be in the US. And then you would have to document that in a clear and robust description of what the eligibility is, what the requirements are, and how this employee meets those requirements. The consistency in what's on paper and what their job duties are going to go a long way in alleviating any red flags or doubts the USCIS has in regards to this individual's qualifications and the company's qualifications when they issue RFEs to get more information regarding the position. So understanding them in the very base level helps them later when there is a request for evidence or any confusion in the documentation that was submitted, so that it can all be hammered out beforehand.
Great insights. I appreciate you sharing that with us. For all of the HR executives that watch our videos, how can companies prepare employees who are applying for L1 visas to avoid common errors in their personal documentation? Any advice in that area?
Yeah, actually, that's also key in this situation, especially when the visa is eventually approved and the individual has to go get a visa stamping at the consulate to be able to enter in on that visa. So I think the employees should ensure that they have complete and accurate history of their employment abroad, supported by payroll records, contracts, letter from the foreign entities, basically certifying that they did those things and those were their job responsibilities. So they need to submit documents that clearly outline the job roles and responsibilities, ensuring that they're consistent between the employee's account and the company documentation that was submitted. And also minor things that can normally take a long time to fix and cause delays in these applications, such as, ensuring the passport validity. You have a passport that's valid and ready to go once the visa is approved, or having letter of recommendations or performance evaluations handy in case you have to document what you've done in the past. So these things take a little digging up, but something you need to have ready before you go through the process.
Really good to know. I want to ask you, what are some common mistakes that you've seen businesses make when preparing their L visa filings? Anything that they should look out for or avoid? Let us know what you've seen.
Yeah, there's quite a few. I think the biggest one is vague job descriptions.
Mhm.
People assume that, hey, when I say software engineer, you know what a software engineer does. I don't have to explain it to you. So what that ends up doing is people just give out, the boilerplate stuff without going into detail. The L1A visa application requires a lot of detail. So does the L1B. In fact, L1B requires even more detail than you would normally put in any other applications. So vague job descriptions, not only do they cause problems, they cause requests for evidence to appear, and those requests for evidence will just ask for the same information, but in much broader detail. Insufficient evidence. Sometimes the problem becomes that there is evidence there, but it hasn't been gathered and submitted. So submitting everything all at once helps the petition, makes it look more presentable in a sense that they have everything they need to make the decision based on what you provided. Um, and then inconsistencies, that's the other one. If the person says on one document that they manage, if the company says on one document that they manage 4 people, and later in the discussion, they bring up another 5th person that they used to manage that was never mentioned in the organization chart or whatnot, then there's that red flag that goes up. It's like, hey, what is the truth? What am I looking at? As an officer reviewing it, they need to know what they're looking at is accurate and consistent so that they feel comfortable evaluating and adjudicating it. So, errors to look out for: vague job descriptions, insufficient evidence, potential issues that could bring up, like such as inconsistencies. Got to look out for those issues. If you can avoid them, your application process will be a lot less painful.
Really great insights there. I want to ask you about adjudication since you did mention that. What are the most frequent challenges faced during the L visa adjudication process that you've seen?
Well, besides the insufficient evidence, the discrepancies,
Mhm.
the thing that um, the main issue that I've seen come up time and time again is the ambiguity around whether the employee qualifies as an executive manager or a specialized knowledge worker. Now, specialized knowledge worker and executive and manager are 2 different uh, categories within this LVC, as L1A and L1B. So there has to be a clear distinction made from the beginning. But the crossover between executive and manager is not as easy. Sometimes these executives can also be managers of people, and they can be managers of managers of a particular function. Whereas managers are simply managers of people, but they can also be in charge of certain department. So it's making that distinction is very important to USCIS, and it can be murky sometimes. And in larger organizations, it is easier to make the distinction, but in more medium-sized or smaller organizations, that can become pretty murky, and the ambiguity can cause problems when they're adjudicating the petitions.
That's very true. If you are watching this video and need help with this process, feel free to reach out to us anytime. We'd love to help you out. You can email us at info@jude.com. So Kirti, earlier you mentioned RFEs, requests for evidence. So I want to ask you, what is the best way to handle an RFE related to an L1 visa application?
Well, I'm not self-promoting here, but get a good lawyer to help you, go through the clear and concise explanations so that you have the supporting documents that go with it. A lot of it is just making sure that you hit the points that are being requested in the RFE, but somebody with experience on how to address those points and what type of documentation has worked in the past is very important to know. So just make sure the documentation is clear and there is no ambiguity in the document that you're submitting. Good label, good headers help.
Thank you for that. How can companies prevent RFEs by proactively addressing issues that are likely to arise in the initial petition?
Well, proactively, so the application, the petition that you file, you just basically have to include the required forms and the required supporting documents. And what those supporting documents are somewhat described in the form instructions and what's put out there, but still it's quite a bit up to the individual preparing it and the companies preparing it to make sure they get the right information in there. So, have really detailed, clear job description showing that this person has specialized knowledge or executives or managers by putting in organization charts. Sometimes we even submit, their documentation that they've created, their meeting minutes that include the presentation that they made to demonstrate the work that they're doing, to give a USCIS an insight of what's going on inside the company. As for L1B, which is even a more difficult to obtain type of visa, you have to provide company-specific trainings, internal memo, more information about the proprietary project information and documents that this individual is going to work on to demonstrate that they have the specialized knowledge that isn't readily available elsewhere.
That's really helpful to know.
Yeah.
So what happens if an L visa application is denied? What are the next steps for appealing or reapplying? I know nobody wants to think about this, but we have to talk about it. So what happens in this case?
Yeah, I mean, denials and are not as uncommon. I'm sorry, let me rephrase that. Denials are more common than people would think, right? It happens no matter how good the application is or how straightforward the application is. And it could be because of numerous reasons, right? So when that does happen, you either file a motion to reopen and reconsider the case, and you submit new facts or something that was, not evident or obvious in the actual filing. And then you can, if that doesn't work, you want to get a fresh start, you can just reapply and just address the issues that were mentioned in the denial. And, working with the right people and the right resources within the organization that's filing it and the attorneys, you can make that application a stronger one next time. There's no wait period as to when you need to reapply. You can reapply as soon as you're ready.
Oh, wow, that's really good to know. No wait period, so you can just, as soon as you get a denial, you can jump back
Right.
on it and perfect. So we are close on time, but I want to ask you one more question. What recent trends in L visa adjudication should businesses be aware of, especially in light of current immigration policies and changes?
Number one, the delays. Um, and not only that, it's just premium processing is so expensive now. The fees pretty much double in most situations when you go with premium processing. But premium processing is totally worth it. Otherwise, then let me just show you the difference between the two. If you do premium processing, you're gonna get a result, whether it's an approval, denial, or request for evidence within 15 days. And if you file a petition in regular processing, it will be several months, 6 to 7, maybe 8 months before you can even either get a request for evidence or an approval. So it can take quite some time if you do regular processing, and the delays are quite painful. When I started working about 10, 15 years ago, the speed was much faster. You were getting a result within 3 months, 4 months. It was a lot more manageable as opposed to 6, 7, 8, 9 months now. So premium processing is more important than ever, and it's more expensive than ever. So that's something that's a business decision you must make, depending on how quickly you need the individual in the US and when you need them in the US, that will guide you on what process to choose. The other two things, RFEs questioning the corporate relationships are a little bit more common currently. They go through these trends what they're questioning more, what they're looking into more. I'm not saying it's necessarily an agenda, but it's something that they're focusing more on when they're evaluating these petitions. And lastly, the L1B petition, it gets extremely scrutinized. Specialized knowledge is getting more and more difficult to prove simply because a lot of the businesses have shared processes and they work off of much larger processes that are out there. So proving specialized knowledge is becoming more and more difficult. And you have to be really ready to address the information in detail if you're going to go with an L1B.
Such great information. Thank you so much, Kirti. That is all we have time for, so that does bring us to the end of our conversation. Thank you everyone for joining us today. A special thank you to Kirti for your time and wonderful insights. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please feel free to send us an email anytime at info@juke.com. Let us know what topic you want to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again for joining us. Thank you so much, Kirti. We really appreciate you.